is the first day of a two-day summit. I know some of you will be here for both days of this program. I do want to reassure you that if you're not able to be here tomorrow for day two, and for those of you who are here today, we have tremendous resources that we've put online. You'll notice that our packet today is very thin. That was difficult for me. As an attorney, I like to print everything out and give lots of information. But I think that we are all moving towards a recognition that we want to have resources available online, make them easy for you to reference online. So what we've done is to put a tremendous amount of information and resources on the FEA website. And it's on a spot on our website that you really can't miss. If you go to our homepage, look at the website, there's a giant logo that says FEA Bullying Summit. If you click on that logo, we have a great deal of information organized under each day of the summit, including introductions of our speakers, bios on our speakers, and lots of information and resources that reinforce everything that we're going through today and tomorrow. So I would encourage you to please take the time to do that and take a look at those resources. All right. So let's look at what we're trying to achieve in our program. We want you to leave here with an understanding of the major legal developments in the state of New Jersey. And there have been significant developments since the passage of the Anti-Bullying Bill of Rights. So we want you to be sensitive to what those are, sensitive to some of the challenges and implementation issues that we've come up with. We do want you to leave here with a greater understanding and sensitivity to issues related to athletics, students with disabilities, and suicidal ideation. These are all very, very complicated issues that are related in some ways to bullying and related in many ways to school culture and compliance. We do want you to leave here with a better understanding of how to apply this law in real-world situations and how to avoid some of the common pitfalls that I've seen and that others in the Legal One program have seen in going around and training on this issue over the past year. And there are some common pitfalls, and it's interesting when we look at those pitfalls. Some of them are honest misunderstandings of the law, because frankly, the law was not written as clearly as we would have liked. And if you put 5 folks together and have them read the exact same language, in some cases we find some honest misunderstandings and misapplications of the law. I do find sometimes, though, that we have pitfalls because the law is written a certain way, and people say, well, I disagree with that. That doesn't make sense. Why would we do it that way? And we do want to try to help you get past those issues. We as a state association, the New Jersey Principals and Supervisors Association, has been very engaged in this issue for many years, and the overall issue of student safety. And I'll assure all of you here, and the vast majority of you are our members, that we are actively engaged in trying to improve this law and trying to make it work even better. So we are working on that front to try to bring greater sense and clarity to the law, to try to streamline and make more effective some of the procedures. In the meantime, we do want to make sure that you comply with the law that we have in place as we speak. So we'll walk through some of those pitfalls. And we'll walk through together some specific steps and strategies that hopefully you can leave with to help us in addressing this difficult law. All right, so where have we been? How have we gotten to this point? The Anti-Bullying Bill of Rights was signed in January of 2011. Seems like it was ages ago at this point. The law was signed in response, to some extent, to some major high-profile issues that we all are aware of. There was the Rutgers freshman student who ended up committing suicide. That issue has come back into the forefront with the trial that we were all following. There was a report from the Commission on Bullying Prevention. Our executive director, Patricia Wright, was a key player in leading that commission's work. And the commission came out with a very powerful report, some of which was implemented in this new law. And we know that some of those strategies have not been adopted, and some of the things that were called for have not been put into place. But that report was in many ways an important effort towards putting this law into place. We have a number of things that have happened since then. In May of 2011, there was the passage of a teen dating violence law. And we are going to talk about that today. That law has not received nearly the same attention that the bullying law has received. But there is significant overlap between the two. There is also a very detailed procedure that you need to follow in implementing that law. And of course, it's a little bit different than the procedures you need to follow in implementing our anti-bullying Bill of Rights. So we want to make sure you're comfortable with understanding how those two laws relate to each other and how we have to implement both consistently. We do have some guidance that's come out from the Department of Education over the last year. That guidance is available on the Bullying Summit site that we created. So we gave you an easy way to access that guidance. The guidance is helpful in a number of fronts. We do have some key questions that are not yet addressed in that guidance, and we're going to try to help you through today. We've also started to see the first glimpses of litigation with the Anti-Bullying Bill of Rights. And we have just seen the tip of the iceberg. We are going to have a tremendous amount of litigation, I'm sure, over the next year or so, as we ask the courts to fill in some of the gaps that weren't laid out as clearly as they should have been by the legislature. And that's part of the problem when you have a law that doesn't carefully think through all of the issues. We leave those issues for our courts to figure out. So we do have one case, KL versus the Evesham School District, that we'll talk about a little bit, that has started to address some issues in the Anti-Bullying Bill of Rights. In January, I'm sure many of you heard about the decision from the Council on Local Mandates, those of you who have been following that issue. The Council on Local Mandates is a little-known entity created following the passage of a constitutional amendment back in 1995. That constitutional amendment said that the state of New Jersey is not going to implement any new mandates without the state paying for them. How many of you think the state has not implemented any new mandates since 1995 without the state paying for them? We've had many that have gone into effect in that time. Nevertheless, we do have this constitutional provision that's been in the law. And we have this entity that was created the following year in 1996 called the Council on Local Mandates, where if a local government entity thinks that there is an unfunded mandate, they can go and challenge that specific issue. And we did have a school district, Alamucci. Anyone here from Alamucci? We've been very active, actually, working with the Alamucci School District. But we had the little Alamucci School District in Warren County who decided to challenge the Anti-Bullying Bill of Rights as an unfunded state mandate. And what did they say? They said that the law does not fully fund the professional development that we need to put in place to effectively deal with this law, and it doesn't fully fund the staffing that we need to put in place to address this law. And there were some compelling arguments that were made by the Alamucci School District on why this law was not fully funded. This Council on Local Mandates agreed with the Alamucci School District and said, yes, we think this is an unfunded, unconstitutional state mandate. But the law is still in effect today. So if the story ended there, we could all go home and there's no Anti-Bullying Bill of Rights that we have to implement. Clearly, the Anti-Bullying Bill of Rights is still in effect. What the state of New Jersey did was look at this local mandates decision and sort of scrambled over the next 2 months and put together a response to provide some level of funding for the new law. And we'll talk about that. There's lots of loopholes, lots of catches in the funding that was provided, but we will walk through what's included there. So the law does remain fully in effect today as we speak. I stress that because we've actually had some principals and school districts call us and say, well, we've stopped implementing this law. We read about the local mandates decision, Council on Local Mandates, so until we hear otherwise, we're not going to address any more bullying issues. Please don't take that approach. We have the law fully in effect. So this new statute that was signed by the governor in March has some key provisions. The statute itself is available on the FDA website in the Bullying Summit section. But some key points. It maintains our current definitions and our current procedures. So nothing changes with how we define bullying, what procedures we have to follow. It does appropriate $1 million. Now, for a state the size of New Jersey, with over 1.2 million kids in 600 school districts, $1 million doesn't go very far, but I guess it's a start. It is a start to provide some level of funding for school districts. So there is appropriated $1 million to the Bullying Prevention Fund. School districts may apply for grants to use for what is called programs, approaches, or personnel. There are some catches to this fund. School districts have to make an affirmative showing that the district has diligently explored all available resources first. So part of what we're doing today is trying to help make you aware of those available free resources that school districts can have access to. We're very excited to have the New Jersey Bar Foundation here with us. For those of you who will be here tomorrow, we're going to have a presentation from Barbara Gantwork in the Department of Education, talking about the great resources that are available through the department. And there are some other free resources that we're going to make you aware of as part of our program, as part of the panel discussion you'll hear later. So part of what districts have to do before you apply for any of this new funding is make an affirmative showing that you've explored and to the extent you can use available free resources. The legislation also creates a task force, a 7-member task force that's charged with looking at the implementation of this new law. And our hope is that through this task force we can take some of our practical experience over the past year. We can take some of the things that we saw a couple of years ago with the Bullying Commission report. We knew there would be certain issues and challenges. We predicted them at that point in time. And hopefully we can get some improvements to the law itself and get some additional support for school districts through the work of this task force that's been established. Those things are not easy to do, but our hope is that we can get some improvements over the next year. All right. So some of the implementation issues that we're going to walk through with you. These are basic questions that sometimes have complicated answers. What is bullying? Seems like a simple, straightforward question. Not so easy. And we'll talk through what we've seen in some of the cases and some of the case law that's out there now to help us answer that question. Who can investigate? And what process do we follow? Those things might have seemed straightforward in the law. We're running into major issues with how school districts address those specific provisions in the law. How do we deal with conduct away from school grounds, including cyberbullying? That's a recurring issue, it's a growing issue, and one that we have to deal with. What information do we provide to parents? Parents are entitled under this law to a tremendous amount of information, and we want to make sure we understand and respect their rights. How do we address staff members who are accused of bullying? This, I have seen, has become a growing issue in schools across the state. We have teachers who are being accused of bullying. We have principals who are being accused of bullying. And the law does cover those situations where staff members are accused of bullying kids. Now, it doesn't cover the situation where a staff member is accused of bullying another staff member. So if your superintendent yells at you, you can't report them under the Anti-Bullying Bill of Rights. Hopefully there's some other ways that we could help you to deal with those sorts of issues. But it's not covered under the Anti-Bullying Bill of Rights. A big issue, how do we address the issue of the school safety teams? What role do they play? How do we avoid legal liability? That's our bottom line, at least in our focus in the first day of the program. And more importantly, how do we create a safe learning environment for all kids? All right. Let's start with the basic question, what is bullying? I'm not going to spend much time on this, but I'll just spend a few seconds walking you through some of the key aspects of our definition. I know you've seen this a million times by now. But we have a definition that is very broad in the state of New Jersey. What type of behavior could be bullying? I could just say anything. Any gesture, any written, verbal, or physical act, any electronic communication. Very, very broad. One of the things unique to New Jersey is that we have specifically said a single incident could be enough for bullying. It does not have to be a series of incidents. So we do not want to get ourselves in a position where we prejudge these issues, where you find out there was a one-time incident between two kids, and you as the principal say, well, that can't be bullying. We're not going to go through this process. That would be a mistake. We still have to work through the process, even if we think this is just a single incident. As far as the behavior that's involved, the behavior has to be something that is motivated by an actual or perceived characteristic. And I have seen in working with school districts across the state that some districts are not addressing this part of the law. They're reporting issues as bullying. I asked them, well, in the first half of the year, we've had X number of incidents. What were the motivating factors? And some districts aren't able to answer that question. They haven't kept that data, even though it's required under the statute. So many of us recognize when you're talking about bullying behavior, it could be race, ethnicity, gender, sexual orientation, disability. It could be a number of characteristics that we recognize are protected under the law, under state and federal discrimination. But there's also this catch-all built into the law that talks about any other distinguishing characteristic. And that is a very broad provision, and we'll talk through what that means and what it doesn't mean. As far as the location of the behavior, just like I said before, and the type of behavior could be anything. Location, it could almost be anywhere. New Jersey has made clear that incidents that occur off school grounds may still be issues that rise to the level of bullying. If the behavior that occurs off school grounds is likely to lead to substantial disruption or interference with the school environment. And we know that when kids start issues off school grounds, that very often comes back into school. And we don't have kids who sort of stop the bad behavior at the schoolhouse door and then pick it up again when they come home from school. So we know that in many ways this stuff is likely to come back into school, including cyber issues. I'll get technical just for a second here, and we're going to try not to get overly technical. We want to get you to understand how to apply all this. But in order to have bullying behavior, you have to meet these conditions. It has to be something that causes substantial disruption or interference in the school or with student rights, and it has to meet one of these other three conditions. So in every one of the reports done by your anti-bullying specialist, they should identify what was the substantial disruption or interference that was caused, and identify one of these other three conditions. What was the physical or emotional harm to the student, or damage to the student's property, or where was the student placed in fear of harm to himself or his property? What was the behavior that had the effect of insulting or demeaning the student or a group of students? Or what behavior created what we're now calling a hostile educational environment? We have to make sure that we are documenting that those conditions are met in order for us to call something bullying. And I'm finding that in many reports that are being done across the state, districts are not doing this. They're not documenting the specific criteria that have to be met for us to call something bullying. So a few sticking points in this definition. Actual or perceived characteristic. It is not meant to include a personality dispute, a relationship dispute. She stole my boyfriend. That's not what we mean by an actual or perceived characteristic. He stole money from me, so I beat him up. That's not what we mean by an actual or perceived characteristic. We have relationship issues that come up that are typical conflict between kids. We have to have an actual or perceived characteristic, which could go beyond the list I gave you. Could include height, could include weight, could include hair color, could include the fact that you're a freshman and it's a senior who's singling you out. Those are characteristics. Some relationship dispute between two people is not considered a characteristic, and we'll talk about that in a little more detail in a moment too with a specific case. We're also talking about substantial disruption. Every day, unfortunately, we're going to have in the real world cases of minor disruption between kids. Two kids are walking out of a room together, one pushes another and calls him a jerk, and you've got some minor disruption. But that's not the substantial disruption we're talking about in order to call something bullying. We also have, according to just about every expert you ask, in order to have something called bullying, there's a power differential that comes into play. Now, I wish that New Jersey had specifically addressed power differential in its definition of bullying. They didn't do that. But just about every expert you talk to will say that that is a key aspect to distinguish bullying from typical student conduct. And my reading of the law and what will come out in the case law is that courts are going to still look to that issue, because that is what experts will say. What makes this different from typical student conflict? There is some sort of a power differential between students. And that power differential can happen for lots of reasons. Could be physical, could be social status. There's a lot of ways you can have a power differential between kids. All right. Let me talk about one specific case that could help a little bit on this issue of the actual or perceived characteristic. Just decided in December by the appellate division of our Superior Court. And one key quote in this case, KL versus the Evesham School District. Harmful or demeaning conduct motivated only by another reason, for example, dispute about relationships or personal belongings, or aggressive conduct without identifiable motivation, does not come within the statutory definition of bullying. So we want to make sure we recognize that. If you can't identify an actual or perceived characteristic, you might have student conflict, you might have a violation of the code of student conduct, then you have to deal with it. But you won't have bullying. We have to have that characteristic in order for us to label something bullying. And it's not these disputes between relationships issues that come up all the time. Questions before I jump on? All right.
Is this PowerPoint going to be available to us?
Yes, let me stress that PowerPoint is on the website. So everything that we're going through today is available on the FBA website. You go to the home page and click on Bullying Sons, and it's all there.
I didn't see this one. This one's not there.
This one is there as of today. I continued tweaking this one through the weekend. That's why you didn't see it. You can get it. You should be able to get it. I'm not sure if we have it at this moment, but you'll have it by the end of today. It's there. Our people are great, so it is there.
Would it be wise to amend policy to reflect the power differential?
Yes, I think that's an important issue. It's something that is recognized by experts across the country. So part of what we have to do is sort of figure out how we distinguish between typical student conflict and bullying. And power differential is a key aspect of that. Now, we have asked the department to help us to go even further. One of the things that we've called for is for the department to come out with a set of examples and scenarios that show incidents of typical student conflict versus bullying. And our hope is that over the next year, the department will work with us and do that, so that we can give you lots of examples of things that fall into either one of those categories. We don't yet have that, so hopefully that's something that will be coming. All right, addressing issues outside of school. That's another important aspect of this law. We've had a duty for many years that goes beyond portal to portal. When we say portal to portal, we mean that to some extent you are responsible for student discipline and safety when kids are going to school and then back home from school. That's something that's been true in New Jersey going back to 1971 in a case called RR versus Shore Region. New Jersey has gone beyond that for many years. The RR versus Shore Regional case, I'll just do the 2-second version of it. You had a student who came home from school, his parents weren't home, he walks across the street to a neighbor's house, that child's parents also weren't home, the two kids get into a dispute, and one student ends up threatening another with a knife. None of this happened at school, all of it happened after both kids had gone home. The school district still took disciplinary action against the student who threatened the other with a knife, and our courts 40 years ago said the school district was within its rights to do that because it was reasonable to believe that the student who was threatened with a knife would be fearful and distracted in school. And that would lead to substantial disruption in school. The same principle holds true when we talk about issues of cyberbullying, things that happen outside of school. In many cases, it's reasonable to believe kids will be fearful, distracted, embarrassed, demeaned when they're coming into school. And we specifically have the issue laid out in the New Jersey Administrative Code now, and we give you the citation for that. So the new law doesn't change the scope of your responsibility for conduct away from school grounds. This is not new. More people are aware of our responsibilities on this front, but we've had those responsibilities in place for many years. And there's a couple of recent cases that you might have heard about that also don't change our responsibilities here. Ramapo versus the Indian Hills School District, or the Ramapo Indian Hills School District. That was one specific case. In that case, you had a school district with what we call a 24/7 policy that says if kids are involved in athletics or other extracurricular activities, we have them agree that they're not going to get in trouble with drugs or alcohol or in any other way get in trouble with law enforcement, even outside of school. That's very common in school districts across the state to have a policy like that. In that particular case, our acting commissioner of education at the time, Rochelle Hendricks, said that school districts do not have that authority to remove kids from extracurricular activities and sports teams just because they got in trouble with drugs or alcohol or in some other way with law enforcement outside of school. So some people saw that decision and said, well, how can we address bullying outside of school if we can't address these sorts of issues outside of school? First, let me say we disagree with that decision. We're hoping on appeal that the decision is overturned because kids do serve as important role models in our schools, especially when you're involved in extracurricular activities. And we do want to be able to hold kids to that higher standard when you're involved in those sorts of activities. But that doesn't deal with one student impacting the rights of another kid. Bullying issues, for many years, our courts have said we have the ability to address them when one student is impacting the rights of another outside of school. So if any of you read about the Ramapo Indian Hills case, be assured it doesn't change your ability to address bullying outside of school. And there were a couple of other cases in federal court that also dealt with conduct away from school grounds. They were kind of horrifying cases to me. Two cases, one called JS, the other called Layshock from Pennsylvania. You had kids who basically pretended to be the school principal, created phony websites pretending to be the school principal, and had the principal saying all sorts of horrific, terrible things. In one case, you had the principal basically acting like a pedophile. So horrible, horrible case. And in these cases, the school district finds out the kids are doing this, creating these fake sites, and they take disciplinary action. Understandably. Our Third Circuit Court of Appeals said that in those cases, the school districts were violating the First Amendment rights of these kids. So we are very concerned about those decisions, obviously, as well. I think part of the problem in these two cases was that both districts thought it was so obvious that this was causing substantial disruption in school that they didn't really take the time to build a case to prove that this was causing substantial disruption in school. But again, those cases dealt with kids talking about adults. They didn't deal with kids talking about other kids. We have a long line of cases where school districts' authority has been upheld when you're dealing with students making those sorts of comments about other kids. So if you've read about those cases, I want to assure you it doesn't change our responsibility for conduct away from school grounds. Questions on conduct away from school grounds? Parental rights. Law provides very strong parental rights protections. Parents have the right to immediately know that an incident or an alleged incident has occurred. And by immediately, I mean the same day. Not the same minute, but the same day that you learn that one student is accused of bullying another student. Principal, or the principal's designate, has an obligation to pick up the phone and contact the parents of both parties, the alleged bully and victim. You do not need the parents' permission to talk to the children who are allegedly involved in the incident. Some districts have run into that issue, where the parent says, you're not allowed to talk to my child until I show up. Any of you ever run into that situation? Yeah. And usually the parent's a lawyer, or they have a relative who's a lawyer, and they tell you you're not allowed to do that. We have a case that goes back many years, Gospi Lopez, that talked about the school district's obligation to provide due process to kids who are accused of misbehavior. And in that case, the U.S. Supreme Court said that school districts have an obligation to tell kids what they're accused of and give them a chance to give their side of the story, not to have the parent present in order to question the student. That goes back to the mid-'80s, that decision. So you do not have a legal obligation to have the parent present. Now, I know as a practical matter, sometimes we decide it's just easier. we'll talk to the student when the parent is there. But I also know that in many cases I hear from administrators across the state, the best time you're going to get information from kids is if you talk to them immediately. In the moment right after an incident occurs, before they have the time to sort of put their stories together and come out with a different version of the truth. So I wanted to assure you, you do have that right.
Do you always call the parents before we investigate?
Do you always call the parents before you investigate? You don't have to call the parent before you start your investigation. You have to call the parent by the end of that day. So as a strategic matter, I'll say this. There might be times where you want to immediately talk to the kids in the moments right after an incident occurs before you contact the parents. And that is permissible. You're allowed to make that judgment call. Do not let the kids go home without having at least tried to call the parents. That's not good. You want to make sure that the parents have heard from you, or you can document you've made the effort before those kids go home.
So what should our response be to a parent who is an attorney and says to us, you cannot talk to my child without me being there? Our response should be...
Good. So what's your response when the parent said you can't talk to my child without an attorney present? First, you have a red flag that's going up because the parent has introduced the concept of having an attorney come in. So one thing you might want to do is alert your superintendent to the fact that you've got a litigious parent, apparently, who might be raising some issues. You want to make sure you're on the same page as a district team when these issues come up. So I would do that. But ultimately, you want to say in a respectful way to the parent that you appreciate their concerns, but you do have an obligation to protect student safety and discipline and promote discipline for the entire school environment. And that means that you do sometimes need to talk to kids immediately. And we do have that obligation to protect the health and safety of all kids. We couldn't function in the schools if you had to have parent permission every time you wanted to talk to a child in the school setting. The schools couldn't work. And we do have, again, that U.S. Supreme Court case that goes back many years, Gospi-Lopez, that talks about your ability to address students as long as you tell them what they're accused of. And we have a long-standing right for school districts to talk to other kids, including witnesses, to address issues. So parents do have other rights. So they have a right to a written summary of the findings of the anti-bullying specialist. So that's something that has to be provided, and I've heard about cases across the state where districts have forgotten to do that. They thought the issue was so silly, so ridiculous, that they short-circuited the process, and there never was a written report done. You don't want to make that mistake.
How much detail should be in the summary that parents receive?
Good. Hold that for a minute, and I'll walk through that in just a second, because you don't have to give the parent everything. So we'll walk through what you have to give.
What if it's you go through and you decide it's not hid? It's a conflict.
Yeah.
Do the parents still get all of that information if you classify it? Because that's,
Yes.
we're not really, it takes us a while to figure out whether it is conflict or if it's hid.
Yeah, the question is, if it was conflict or if you still provide the same information.
As the APS, do I still have to give everything over to the parent if it's conflict?
The parents have the same rights to information whether you find that there was bullying or not. What we have to keep in mind here is that this law creates a very formal process that has to be followed every time there's an allegation of bullying. Because the parent might disagree with you. The parent might want to appeal and go to the Board of Education and say, we think you were wrong in the decision that you reached. So they're entitled to the same information, and we'll walk through the details of that in a second.
Just double checking, when you say not needing parent permission and parents can't deny you interviewing kids, does that hold true for bystanders and witnesses as well?
Yes. Yeah, you have the ability to talk to kids in the school setting in order to deal with allegations of bullying and many other student safety issues that could come up in the school setting. That would come to a standstill if we needed permission every time we tried to do it. And our courts have recognized that. So we're going to walk through this in some more detail in a second, just a quick overview of the parent rights. They have a right to a hearing before the Board of Education, and we'll walk through the logistics of that. If they don't like what the board says, they have the right to appeal that decision to the Commissioner of Education. They also have the right, if there is some potential violation of state or federal discrimination law, to go into state or federal court, or to go to the New Jersey Division on Civil Rights and have that entity investigate the school district. And sometimes you might think the case is done. Parent hires a private attorney. They have up to 2 years to file in state or federal court. So record keeping is critical. You are not going to remember all the details of this case 2 years later. It's important that you have the records. All right. So let's go into a little more detail about parental rights. The parents of both parties have the right to notice on the same day an incident occurs. The statute talks about the parties involved. That means the parents of the alleged bully and victim. Not all the bystanders, not all the witnesses, but the parents of the bully and victim have the right to notice that day. You do also have to have a plan to address foreseeable issues that occur. So an alleged bullying issue happens on a field trip. The statute doesn't make an exception where it says you don't have to contact the parent if the kids are on a field trip. So your staff needs to be able to coordinate this stuff. If you have staff chaperones who are on that sort of a field trip and a bullying or alleged bullying issue comes up, you still have to make sure the parent is notified by the end of that day. And that's going to take some level of coordination. You've got an issue that comes up at the football game that's happening that night. You still are supposed to try to contact the parents that day. These are foreseeable, if challenging issues. It's over the weekend, it's at night, it's out of state, but the statute doesn't make exceptions for those issues. So you need a plan to have somebody, the principal or the principal's designee, still informing the parent that we have this allegation that is going to be addressed. The parent also has the right to written notice within 5 school days after the results of an investigation are reported to the board. And that process is commonly misunderstood. So what has to be included in the written report? The nature of the investigation. So at least some information on what were the allegations. The allegation is that Johnny beat up Billy because of his sexual orientation or his perceived sexual orientation. Whether the district found evidence of harassment, intimidation, or bullying. And the parent does have a right to know whether discipline was imposed or services such as counseling were provided. So you might have some cases, and we'll talk about this a little bit later, you might have a case where a student with disabilities is found to have bullied another student, and it turns out the behavior is a manifestation of the student's disability, and it might be a case where you're not allowed to impose additional discipline. So you may have cases where a student engages in bullying, and you're not allowed to impose discipline. We're going to have to make sure parents are informed in those cases that discipline was not imposed. The challenge is that you can't say it was not imposed because this is a student with disabilities. The student has confidentiality rights, so you're not allowed to share that piece of information. What you can do is generally educate parents about special education law, and that there will be times where behavior is a manifestation of disability. But you can't, in a specific case, reveal that information about a specific child. So we do have one case now that I mentioned before that suggests the parents are entitled to broader information beyond that general information I just described. And I think this is where New Jersey is going. And it's the first case, so this has to play out over the next several months. But again, KL versus Evesham. In that case, the court held that the parent had the right to see the school district's disciplinary referral form with appropriate redactions. So, in that case, it wasn't just a final report that the parent was entitled to see. They were entitled to see the initial report that was made by a staff member, the initial disciplinary referral form. The form had information about the alleged victim and aggressor, so the court said the parents on both sides were entitled to see that information. The form had to be provided, according to the court, under federal law, under FERPA, under the Open Public Records Act, and under common law, to the parent, not to the rest of the world. And the court suggested in this case that there was nothing in the Anti-Bullying Bill of Rights that was intended to modify existing pupil records law. So, I'll stress this is the very first case that addresses this particular issue, but this case strongly suggests that parents will be entitled to see the full anti-bullying specialist report with appropriate redactions, which means you would take out the names of all the other kids who are involved, rather than just a summary report. Our hope, frankly, was that the parent would have been entitled to see the summary report, not the full detailed report. But our courts seem to be suggesting additional information the parent will be able to see. I see the back.
When you say disciplinary referral form, you talking about the school's disciplinary referral form?
Yes. This specific case dealt with the school's disciplinary referral form. That's what the court was talking about in this particular case. And my reading on this is that if the court says this here, and this particular case took place before the new anti-bullying Bill of Rights, but if the court says that parents are entitled to this information here, it's difficult for me to see where they would carve out an exception where you're entitled to information in every other discipline case, but not in bullying cases. So I suspect the courts are going to say that you're entitled to this information in bullying cases as well.
So, on our report form that the teachers or whoever would fill out, it has a spot there where we ask for, do you know, can you say some names of anybody else who may have information about this, being the bystanders? Are you suggesting we should take that piece out of the report form because it could end up going to parents?
You have to take, the question is, we take that piece out of the form. My answer is yes for any information that goes to parents. So if a parent asks for, and the district provides information on one of those reports, you should be redacting all student names from there, even witnesses. Parents should not be seeing the names of other kids who are witnesses. Okay, those kids have their own rights.
And statements written by students other than
It's likely, again, this is the first case we've seen, so I'm cautioning my language here. It's likely our courts will say the parent is entitled to that information with redactions so that you won't know the names of the kids who are making those particular statements. Now, this is the very first case that we've had on this issue, but it looks like that's where the court's going.
That was kind of my question, because I think in our district, we have the initial report, then we have the investigation report. So are they seen as two different things, where they would have access to the initial and not the investigation report?
Well, the parent is clearly entitled, under the Anti-Bullying Bill of Rights, to a summary of the final investigation report. Reading this first decision, it looks like our courts are going to say parents are entitled to the full report with redactions, so you don't see the other kids' names. That seems to be where we're going.
I just have a question. We found a situation not to be bullying, and our explanation was we found this not to be bullying under the, through interviews, under the definition, it did not meet the ACE definition, did not meet state criteria. The parent wants further detail. They want more details for our findings. What more details could we possibly give?
The parent doesn't have the right to force you to create documents that don't exist. So they can't force you to write a new report, further justifying your findings. To the extent that investigation documents, reports do exist, it appears the parent is going to be entitled to those with redactions.
So she can file an Oprah.
She could file an Oprah request,
And have to give her.
and she'd be entitled to certain information. You take out all the other kids' names, you might have to take out all the staff members' names, but it looks like the parent will then be entitled to that report. And again, I would feel better if we had 10 cases that I could report to you on this. We have one. It's the only one that's out there, so I can't report on things we don't have. But this was the first case reported on this issue, and it suggests where the state of New Jersey is going.
You mentioned staff members' names. Did the staff member's name be on that referral form?
The staff member's name is on the form. I would redact that name too until we're directed otherwise by the courts. I would err on the side of trying to protect staff member confidentiality.
But in the initial incident report, you say they may be entitled to that, so you mentioned.
Yes.
In there, it says how you learned about the incident. Now, eventually, the parents can find out who initiated the incident, whether the student reported it or anything like that, correct?
Eventually. Now, eventually is an important point because a parent can eventually find out who initiated the investigation if they decide to go into state or federal court. That's the point in time when you're actually suing the school district that you would be entitled through discovery to that information.
And is it your thinking that they would be able to find that out as soon as they see the citizen report? Because on there, you're basically saying if you learn from the victim, or if you learn from somebody else, the additional incident.
It's a good question. I think even with redactions, parents are sometimes going to be able to read for context, and you're going to figure out who the person is who made the initial report. I would argue that you want to redact enough information to protect student identity. So it might not just be the name, it might be the fact that it was the victim who reported. You might redact that piece of information too. Yes, that's what I would err. It's better for us to err on the side of protecting student confidentiality until the court specifically directs otherwise. That's where I would err. All right, student surveys. I do want to talk about this issue for a moment. This is important because the Department of Education and many programs, including programs that we work with, great programs, talk about school climate and culture. And one aspect of how we assess the current climate and culture is to assess and survey students and try to get a sense of where they are with bullying and other climate issues. New Jersey has a specific law in place that many other states do not on this issue. New Jersey's law requires 2 weeks prior notice and parental permission in order for certain surveys to be given to kids, even anonymous surveys. And I give you the citation here for that specific law. It applies to surveys that reveal certain information. So, for example, if you're asking about information that could address mental and psychological problems that are potentially embarrassing to a student, and having been bullied could lead to mental and psychological issues that are potentially embarrassing to a student, and you're asking about that, you need prior parent permission. If you're asking about illegal, antisocial, self-incriminating, and demeaning behavior, which certainly could be bullying, you need to have prior parent permission in order to ask those questions of the kids, even on an anonymous survey. So we want to make sure you're aware of that, and that before you administer any of those surveys to kids, you're complying with this specific law. And again, there are great programs that have us talking to kids and surveying kids. Yes?
Can you use implied consent if you're notifying them and they don't want their child to be notified?
Good question. Good question. Can you use implied consent versus affirmative consent? The answer is no. New Jersey has made it more challenging. Our law requires the parent to affirmatively sign a permission form and turn it in order for us to be considered to have consent from that parent. And frankly, I wear my lobbying hat 10 years ago when this thing was passed. I was Assistant Director of Government Relations. We expressed a lot of concerns at that time about the law, but it did pass. So it does require affirmative consent where the parents send in a permission.
Isn't there a new thing that's out there right now that I think it was just the subcommittee or one of the committees did approve that it's going to go back to an opt?
Yes,
out?
there is a proposal to change the law that would change it back to an opt-out where if you don't hear from the parents, there is implied consent. And we're supportive of that. It has not passed yet. So our hope is that a few months from now we'll have a different answer on this question. But as of now, you do need that parent permission. Make sure we're on time. All right. Let me try to quickly work through the last part of this so we stay on schedule. Who investigates and how? Some key points in the investigation process. The anti-bullying specialist must be our lead investigator. Can't be the principal, can't be the assistant principal. We might not like that. We might think it's not a good provision in the law. It is the law in New Jersey. And if you're the lead investigator, that means you, as the anti-bullying specialist, need to be in the room when the alleged bully is being talked to, when the alleged victim is being talked to. That's what New Jersey requires. You need to be that person who's leading the investigation.
We had nobody besides our principals to do it. We had no guidance counselors, no child studies. So we were told that if you have to use the principal or the assistant principal, then to use it, then to use that. Is that? Are we still okay with that?
The key is getting approval from some aspect of the New Jersey Department of Education. So what I've suggested when districts are in that difficult position is to reach out to your county office and to get somebody from the county office to say that in your circumstance, this is an appropriate response. Because those problems are coming up all the time. Technically, the statute says you can use a teacher. Now, that is not a good solution, to use a teacher to be your anti-bullying specialist. That's why I would make sure to go to the county.
Can you also have other, like, liaisons that used to be called in school, help do the investigation, say, because if one person is doing it, they could be completely overwhelmed with their other duties.
Yes.
And have other people investigate just as long as the ABS is doing the bully and the victim?
You can have other people who assist the anti-bullying specialist, and that's where you sort of have to do a triage approach. You know, you have to assess who are the most critical folks to be investigated, bully, victim. Maybe there's a smaller set of witnesses that anti-bullying specialist better be the one to talk to. You may not have to have the anti-bullying specialist talk to every one of the 30 witnesses that you're going to be interviewing.
Because the other issue that I have is, as director of school counseling, my school counselor is the ABS, but then she's investigating her kid. That creates kind of a contradictory, conflictory kind of role where she's supposed to be an advocate and now she's the investigator.
I understand that, and that is a conflict that's inherent in the law. The only thing you could do there, the statute doesn't say you only have to have one anti-bullying specialist per school. You can have a second anti-bullying specialist, so when that issue comes up, now you don't always have a second person you can assign, but if you have that ability, you could have a second guidance counselor, somebody else filling in when you have that situation.
Has that changed? Because my understanding was one ABS per building.
The Department of Education has come out, and we're waiting for their interpretation on this, has come out with a written Q&A document that says that you can appoint a second anti-bullying specialist. So that was something that we were waiting on. It did come from the Department of Education. That's their interpretation. That's why I feel comfortable giving it.
Can the investigation also be conducted through the school safety team, members of the school safety team?
Good. Can this investigation be done by the members of the school safety team? Not as members of the school safety team. That is not their function to investigate specific allegations. It is their function to address the overarching issue of school climate and culture. So we want to make sure the team doesn't get lost in doing this role. Now, you might have some members of the school safety team who are also appointed by the principal to assist with investigations, but not because they're on the school safety team. It's a different function. Let me just quickly hit a couple of points, and we'll hold off on questions so that we stay on the schedule. The superintendent's role is to decide on discipline and other interventions. It is not their role to change the findings of the anti-bullying specialist. And this is a controversial issue that's come up. We have had superintendents directing anti-bullying specialists to change their findings. I had this discussion, and I was told I could quote her, so I will, with Sue March from the New Jersey Department of Education, who is the lead person at the department overseeing this. And her interpretation, consistent with ours, is that the superintendent does not have the authority to change the findings of the anti-bullying specialist investigation. The superintendent's role is to decide what we do about it. What discipline do we impose? What other interventions do we impose? The superintendent can certainly share his or her opinion with the board about the report if they have some misgivings about the report. But they shouldn't be changing or ordering changes in the report.
What is no leeway to screen cases? On your PowerPoint, no leeway?
Oh, no leeway to screen cases. Let me just say there, if you see something where a parent says, you know, Billy and Johnny were playing Cowboys and Indians, I think that's bullying. And you know, this is just two kindergartners playing Cowboys and Indians. It's not bullying. In the real world, prior to this law, we wouldn't have gone through a formal investigation. But under this law, once you have an allegation of bullying, you need to go through the process. You need to actually assign it to the anti-bullying specialist, have them do a report, have it go to the superintendent and go to the board and go through the process. Even though some of the allegations might seem silly, might be obvious to anyone who looks at them, that they're not bullying. You have to go through the process. There is no leeway to screen cases, even if they're clear on the face that they're not bullying.
If a parent calls in, says, my daughter's being bullied on the bus, whatever, we say to them, okay, we're gonna go through the process, this is the process that you go, I don't want to go that far.
Good.
I just want you to talk to them and.
Very good. Parent says, my child's being bullied, then you say, I'm going to go through the process, they say no. You have to look at this the way you would a child abuse issue. Once you have information to think a child might have been abused, you have to report it, you have to have the process play out. It's the same thing here. You can't stop the process. Once you have information to think a child might have been bullied, the train has left the station, they like to say.
Even though they don't know what that word bullying means, it was used very loosely.
Even though they don't know what that word means. Part of our challenge is to educate kids, and educate parents. But you have to do it separate and apart from the specific allegation. Now, not every report has to take 10 days, right? The anti-bullying specialist can conclude in a half hour that this was not bullying, and get that report done and send it off.
That phone call that goes home to the accused is not always a pleasant phone call when you find out it was a minor issue and it wasn't even a fault.
I understand that. Those calls are not always pleasant, but we do have a process. It's not your fault, and in some ways it doesn't hurt to just point to the law and say we are required to go through this process in every case.
Could you, while you're on the phone with the parent that uses the word bullying, can you ask them, can you kind of get them to describe what they're talking about and then determine? Once they use the word bullying, you have to go. Like, it's totally not.
A parent calls you and they make an allegation of bullying, and then can you ask them to describe it and really figure out whether it's bullying? You can ask them to describe it, and probably should, so you get a little more information. But I would not short-circuit the process. What you don't want to do, this is my fear, I put on my attorney hat here. My fear is that at some point a parent's going to accuse you of trying to talk them out of filing a report. And all you might have been doing in good faith was gathering information and trying to figure out whether this really is bullying or not. But the statute says every time there's an allegation, it has to go through this process. So you can't unhear what you've heard. You heard a parent say that a child was bullied. So don't screen that process. I am fearful the case will be coming where the parent makes that allegation, that the principal talked me out of this. And then the courts are not going to be sympathetic to that in this environment. It's critical for you to train your staff so that they don't throw the bullying label on every conflict they see. Right? If you see a conflict as a staff member and you just factually describe to the principal what you've seen, now you have some leeway. Now, so if you as a staff member see a conflict between two kids and write it up and tell the principal what you've seen, and you don't throw in the label bullying, the principal can assess that report and figure out whether it potentially meets the criteria of bullying or not. Once the staff member uses the word bullying or harassment or intimidation, you have to go through the formal process. So if your staff members have a case that's not obviously bullying, if it's obviously bullying, report it as bullying. If it's a case that's not obviously bullying, they don't know that there's a perceived characteristic or some other part of the definition, just report the incident and allow the principal to look into the incident and figure out whether it needs to go onto the bullying track or not. Because once it gets on the track, you can't take it off. Sounds like what? But now you've got a staff member who has not thrown out a specific allegation of bullying. Don't use the words harassment, intimidation, or bullying. Anything else, you can use your common sense. So that is a strategy. All right, let me finish this up, and then we'll have time for questions. Whether or not a parent requests a hearing, you have to have the board affirm, reject, or modify the superintendent's decision. Every single case. So board should be hearing these cases twice. They should get an initial report of the allegation. Then the information goes home to the parent. Then the parent might or might not request a hearing. Whether they do or not, the following month the board should be affirming, rejecting, or modifying the decision that's reached. So that's a two-step process for the board. And a lot of districts are not doing that and not following both parts of that process.
Quick question. Are you doing, as a coordinator here, is this information going to the superintendent, or is it up to us to get that out to our superintendents now?
The superintendent, the statute has information going directly from the anti-bullying specialist to the superintendent. Now, the coordinator needs to be in the loop and should also be copied on all this information. But there's a requirement for it to go right to the superintendent. So
Sorry,
you,
I don't think you understood
I'm
my
sorry.
question. You're giving us really good information. Our superintendent does report to the board. I think they've done it once. They do it one time. I don't think we've ever had a follow-up. So is your information that you're giving us being sent to the
Yes.
superintendent? Or are we going to go back and do that?
well, I hope both. The information I'm giving you is the same information the Department of Education has given out in trainings. But I see this has not gotten through. The message has not gotten through in a lot of districts. So this is a two-step board process. Step one, the board is informed. Then the parents get the information. Parents might or might not ask for a hearing, but whether they do or not, step two is the board affirming, rejecting, or modifying the decision. Staff members accused of bullying, we'll put into our parking lot and address later, but that is an important issue. We'll deal with it in a scenario. And there's a number of issues to consider there, but we'll walk through them with one of our scenarios. So, school safety teams we'll also put in our parking lot. So we've got staff members accused of bullying, school safety team issues. We'll talk through those functions with the scenarios that we apply. Implementing other laws, we'll also deal with in our scenarios. We're going to specifically talk about the teen dating violence law. So we'll go through that law in some detail with you. Again, all this is available on our website, so I want to make sure we can stay close to on the schedule. And there's a number of other statutes we'll touch on some of those as well that you need to be sensitive to, including the sexting law that was put in place in New Jersey, that in many cases will require you to contact law enforcement. Students send explicit images on their cell phones. They're sending them back and forth in other ways electronically. That's information that law enforcement does need to know. And another issue that we'll touch on when we talk about the scenario on teen dating violence is statutory rape. One thing I'll say now, just as we close up on that issue, you have to be sensitive to age differences between kids. You have a freshman student or an 8th grade student who's 13 and a high school senior who's 17. You've got more than a 4-year gap between those kids, even if you have a consensual sexual relationship. And you have the one student who is under the age of 16, you now have what could be considered statutory rape. So even in consensual relationships, if you have that 4-year gap, you want to be sensitive to that. We give you a number of websites that you can look at, and again, if you go to the Bullying Summit site, there's a lot of information there that goes into detail on all the things that we've talked about. So with that, let's take a 10-minute break. I want to thank you for listening, and when we come back, we're going to have Coach Randy Nathan talking about athletics. So thank you very much.